If you are linked for this proceedings, kindly unmute your mic. Unmute your mic.
Okay. My Lord, my learned friend is my learned is joining back, sir.
All right.
He was thrown out at a point, sir.
Please, if you are on, kindly announce your appearance. Is the claimant counsel online now?
I'm on the line, sir. Is the defendant we are is the defendant we are waiting for, sir?
I think this is the most mixed up file so far. Like the last process. This is the last, this volume 3, and it's carrying notice of appeal. Notice of appeal that should be in volume 1. This in the check now. Check the bottom volume. You can even find them there because this file is the most disorganized. Okay. Yes. Counsel.
Yes, my Lord.
Hello, yeah. Yes.
Yes, sir.
You know, we cannot just be online waiting for him like so. Yes, let me hear you.
My Lord, the claimant's final written address is filed
The matter
on
is adoption.
adoption, sir.
Yes.
And we are ready.
Isn't it?
Yes, sir. Parties have filed their pleadings, their final written addresses. So,
You are ready for it?
yes, I'm ready, sir, if the business of the court permits, sir.
Okay. Let's go ahead and adopt.
As copies.
At least the rules allow me to adopt final written address for it.
As copies, sir.
Yes.
So, my lord, the claimant's final written address was filed on the 15th of July 2024.
15th July.
Yes, sir. 2024, sir.
Yes.
That was subsequent to the defendant's own final written address. My lord, we adopt this
No, that final written address filed on
it's filed on the 15th of July, sir, 2024.
You said you file your own on 15 July 2024.
Yes, sir. Oh, okay. Sorry, in reply to the
defendant's final written address filed
address,
on.
it was filed. I am not with his own, no. I'm sorry, sir. Oh, it was filed, sir, on the 27th day of June 2024. 27th day of June 2024.
You adopt the claimant's final written address and
urge that my lord to grant all the relief sought by the claimant in this case.
the defendant's final written address filed on 27 June 2024 is hereby deemed adopted.
And he also filed a reply, sir. He filed a reply. He filed a reply dated the 23rd of July 2024, which was also filed at this court too on that date, sir.
Which date?
23rd July 2024.
Is deemed adopted with the reply filed on 23rd July 2024.
Yes, sir.
Yes. I have gone through the processes and my judgment is ready. Are you ready for the judgment?
We have no choice, sir.
No, you have a choice. You have a choice.
No, sir, we have no choice.
Though you have said nothing new besides what is already submitted. But I am giving you a choice.
No, sir. We have no choice, sir.
So are you ready? You say we are ready.
I'm ready. We are ready. We are ready. We are ready for the judgment of the court.
Doctor Onyeyike. This is the judgment of the court. You said you are Damulak Olowo.
Olowo Yeye, sir.
Okay. Okay. The claimant took out a general form of complaint against the defendant on 18th October 2018. processes were exchanged. The claimant, by a Zoom-compliant complaint filed on 28 February 2024, pressed for the following reliefs: a declaration that an allegation of plagiarism against the claimant cannot be made against the claimant in the absence of the works or publication of a particular author or authors the claimant has purportedly plagiarized, specifying what part of the works were copied, printed, or passed off as the original works of the claimant without the claimant having acknowledged such works. There are prayers follows there to set aside the report, set aside the suspension, and set aside the dismissal, and an order directing the defendant to pay the claimants all salaries and allowances due to him since October 2018, when the defendant suspended the payment of the claimant's salaries and allowances till date of judgment, and general damages of 100 million naira. Case of the claimant is that he was an employee of the defendant. He applied to be promoted from a reader to a professor. He underwent the processes from the faculty, that's the departmental appraisal and faculty appraisal committee, and he was recommended for promotion by both committees. Same was transmitted to the University Appraisal Committee for transmission to the Appointment and Promotion Committee. Rather than receive the result, he was queried that he plagiarized some work in the course of his thesis. He was never given the plagiarized work. He was queried, he appeared before the committee, but he was never given the work he was alleged to have plagiarized. Then, in the process of that, he was given another query that he failed to submit research report with the sum of 1,685,000 naira released by TEDFund in 2016 for his research. He also responded and explained that he had submitted the report. He was made invited to appear before disciplinary committee on the 26th October 2018, and then on the 31st October 2018, he received a letter of dismissal. The dismissal letter placed reliance on the staff disciplinary committee on TEDFund intervention grant, which was signed on 11th November 2018. That's Exhibit 20. He alleged that he was not given fair hearing. The case of the defendant, most of the facts are admitted. The defendant said the man was given fair hearing, the claimant was given fair hearing, that he refused to appear before one of the committees, and that the defendant followed the procedure in dismissing him. In the final written address, defendant, Senate Council formulated 5 issues for determination. Issue 1 is on the competence of the suit and failure to confer jurisdiction on the court. Issue 2 is complaint, that the complaint of 28 February 2024 is neither signed by counsel nor by claimant. Issue 3 is whether on the preponderance of evidence the claimant is entitled to any of this relief. Issues 3, 4, and 5 are whether the defendant validly suspended and finally dismissed the claimant. Supposing that the complaint is competent, the release must fail because the defendant has the power and it followed the enabling acts and the regulations in dismissing the claimant. Claimant's final written address. The claimant counsel formulated 3 issues. Issue 1 is whether the defendant acted in accordance with its regulations and the act establishing the defendant, which he answered in the negative. On issue 2, which is whether there exists fact in support of the allegation. He answered in the negative, that there was no external examiner's report, as same was not presented in evidence. On third phone intervention grant, counsel submitted that there are no evidence. The respondents on the defendant's address, in response to the defendant's address on the competence of the suit as to whether the complaint was signed by counsel or claimant, counsel submitted that the complaint was signed by counsel Yetunde Olowoyeye, on whether the provision of section 117 of the Evidence Act is applicable to this
Are you listening? Can you hear?
to counsel. Preliminary objections. The first objection raised by learned defendants counsel submitted that claimant adopted both his depositions of 29th June 22nd, 2022 and 28th February 2024. That what is alive and valid is the amended process of 28th February 2024. Cited the case of Ramen Enterprise Limited and others versus Springbank PLC and others. That the amended complaint of 28th February 2024 is neither signed by counsel nor by claimant, contrary to Order 4, Rule 43 of the rules of this court. That this affects the validity of the process and thereby renders the complaint incompetent, which borders on the issue of jurisdiction and the competence of this court to adjudicate on the matter. Let me agree with learned defendant counsel that once a process is amended, the previous process is done away with, and the extant process becomes the amended process. See Mobile Producing Nigeria Unlimited versus Etukudo 2011 citation supplied, where the court held the effect of the amendment is that once a pleading is amended, what stood before the amendment is no longer material before the court and no longer defines the issues to be tried. In this case, the amended process of 28 February 2024 is the extant process with life before the court, and I accordingly discountenance the process of 29th June 2022 adopted by the claimant. Let me also agree with the defendant counsel that failure to sign the complaint by either the claimant or counsel will render the process incompetent and deprive the court of jurisdiction. I have cited the case of Williams and Adolf's term International Nigeria Limited, Julius Berger Nigeria Limited versus Udofia Citation Supplied, Associated Bus Company PLC versus Idoco Citation Supplied. I have looked at the file copy of the amended complaint of 28 February 2024 before me. I agree with the claimant counsel as it is my findings that the complaint was signed by Yetunde Olowoyeye Esquire, who is listed as the second counsel at page 22 of the process, and whose evidence of payment of practicing fees is attached after the list of documents immediately after page 41 of the process. The process was signed by writing the name Yetunde Olowoyeye Esquire in the space provided for signing. Now, what is signature, or what amounts to signing a document? Signature can be a person's name or any mark made by that person. In Dr. Bolaji Akinsonya and another versus Federal Mortgage Finance Limited, the court held the word signature is defined in Black's Law Dictionary, 7th edition at page 1387, thus: a person's name or work written by the person at the person's discretion. Any name, mark, or writing used with the intention of authenticating a document. See also the vessel, MV Naval Agent and others versus Associated Commodity International Limited Citation Supplied. This objection accordingly fails and is dismissed. The second objection is that the claimant adopted the position of 28 February 2024 as his evidence, but admitted in cross-examination that he relocated to South Africa in 2019 and since then had not come to Nigeria. The question is, when did the claimant appear before the commissioner for oaths to sign his deposition? He was not in Nigeria on 28 February 2024 to depose to his oath before the commissioner, authorized to do so by law, that the claimant's pleadings, not supported by credible evidence, is deemed abandoned. The response of the claimant counsel is that Section 109 of the Evidence Act, Amendment Act 2022, provides that any affidavit sworn before any judge, officer, or other person duly authorized to take affidavits in Nigeria, whether in person or through audiovisual means, may be used in the court in all cases where affidavits are admissible. On the face of the document, the claimant deposed to a witness statement on oath before the commissioner for oaths. In cross-examination, claimant said he left for South Africa since 2019 and had not been to Nigeria since then. This is not the first time. This is not the first time such a situation and argument is arising. Let me tailor a long extract from the judgment of Biobele Abraham George Will, JCA, at pages 21 to 27 in I and others versus Jato and others, 2024, LPELR 61775CA. This is what my Lord says. I am cutting and pasting. That is, I'm cutting and joining. That is why I said tailoring. This is what my Lord said. It's a long cut. Listen carefully. On the face of the PW1's written statement on oath, it is shown to have been sworn to before the commissioner for oath at the registry of the lower court. However, under cross-examination, the PW1 had testified that he signed his written statement on oath at his counsel's chambers. It is on this basis it has been vehemently contended by learned counsel for the appellants that the written statement on oath of the PW1 has been shown to have been sworn not before the commissioner for oath as required by law, but in the respondent's counsel's chambers, and therefore not admissible in evidence and ought not to have been relied upon by the lower court in the judgment appealed against. Now, by Section 111 of the Evidence Act 2011, it is provided inter alia as follows: the fact that an affidavit purports to have been sworn in the manner prescribed in the preceding section shall be prima facie evidence. However, looking at Exhibit D1, it is clear that it was sworn to before the Commissioner for Oath at the Registry of the lower court. I am unable to agree with the vehement but now seemingly erroneous contention of the learned counsel for the appellants that the evidence elicited from the first respondent as PW1 amounted to an admission that his statement on oath as in Exhibit D1 was sworn to in his counsel's chambers. PW1 did not say so, as all that he said was that he signed his statement on oath in his counsel's chambers, and nothing more, nothing else. My lords, let us leave the issue of the meaning of the word signed and sworn now and proceed to consider whether the evidence elicited under cross-examination of PW1, the first respondent, proved, as was vehemently contended by learned counsel for the appellants, that his statement on oath was not sworn to before the Commissioner for Oath as required by law, and therefore incompetent and inadmissible in evidence. The law is well settled, first, that once a fact has been reduced into writing, oral evidence would not be admitted to vary and or contradict the facts contained therein. Secondly, and more importantly, evidence elicited under cross-examination is admissible if on facts pleaded either by the adversary or by the party being cross-examined and not otherwise. In other words, evidence elicited under cross-examination on facts not pleaded by either of the parties would go to no issue. See Dagash and Bulama citations supplied. See also Olumoroti and Idemeko citations supplied per Biobele Abraham Joshua JCA. I have scanned through the entire pleadings of the appellant as well as those of the respondents. I cannot find where the fact of where the first respondent's written statement on oath was sworn to, whether before the Commissioner for Oath or in his counsel's chambers. There is also nothing on the face of the written statement on oath of the first respondent showing that it was sworn to in his counsel's chambers. So can the evidence elicited from PW1 under cross-examination on facts nowhere pleaded by either of the parties go to any issue as to render the written statement of PW1 incompetent and therefore inadmissible? I think not. Furthermore, can the oral evidence of the PW1 elicited under cross-examination vary the contents of the written statement or oath as to whether and before whom it was sworn? I still think not. Now, assuming for a moment, but without so deciding, that the evidence elicited under cross-examination of PW1 can in law amount to varying the contents of Exhibit D1 to show that the PW1 sought his written statement on oath in his counsel's chambers, then, assuming the written statement on oath of PW1 rather had on his face that it was sworn to before the respondent's counsel in his chambers, and under cross-examination, the PW1 had testified that it was rather sworn to before the Commissioner for Oath at the Registry of the lower court. In law, can this evidence be admissible to prove that such a written statement on oath was sworn to before the Commissioner for Oath, contrary to what is written on his face? I think not. In the light of all the above, therefore, I hold that the evidence elicited from the PW1 under cross-examination cannot and does not vary or contradict the facts as stated in Exhibit D1 that it was sworn to before the Commissioner for Oath. Thus, Exhibit D1 was sworn to in compliance with the requirement of Section 111 of the Evidence Act 2011 and did not in any way offend against Section 112 of the Evidence Act 2011 as was thought, though erroneously by the learned counsel for the appellants. Thus, the mere signing of the written statement on oath, even if in his counsel's chambers, neither vitiate nor rendered Exhibit D1 inadmissible. CFCMB versus Zarami, citation supplied. I hold firmly, therefore, that Exhibit D1 was competent and admissible and was good evidence before the lower court, to be used in his evaluation, findings, and decisions one way or the other in his judgment. Quotation clause. Adopting the reasoning in the above decision and applying same to this case, I now say, on the face of DW1's written statement on oath, PW1 written statement on oath, it is shown to have been sworn to before the Commissioner for Oath at the registry of this court. Under cross-examination, the PW1 had testified in cross-examination that he relocated to South Africa in 2019 and since then had not come to Nigeria. It is on this basis that it has been vehemently contended by learned counsel for the defendant that the question is when did the claimant appear before the Commissioner for Oath to sign his deposition. He was not in Nigeria on 28 February 2024 to depose to his oath before a commissioner authorized to do so by law, that the claimant's pleadings not supported by credible evidence is deemed abandoned, intoning that since the claimant was not in Nigeria on 28 February 2024, he could not have deposed to a witness written statement. So the claimant's pleadings are not supported by evidence. Now, by Section 111 of the Evidence Act, it is provided as inter alia. It is provided as follows. The fact that an affidavit purports to have been sworn in the manner prescribed in the preceding section shall be prima facie evidence. However, looking at the deposition of PW, it is clear that it was sworn to before the Commissioner for Oath at the registry of this court. I am unable to agree with the vehement but now seemingly erroneous contention of the learned counsel for the defendant that the evidence elicited from PW amounted to an in cross-examination amounted to an admission that his statement on oath was not sworn to in this court registry. PW did not say so, as all that he said was that he relocated to South Africa in 2019 and since then had not come to Nigeria, nothing else. The questions asked by the defendant counsel are rather rhetorical as follows. The question is, when did the claimant appear before the Commissioner for Oath to sign his deposition? He was not in Nigeria on 28 February 2024 to depose to his oath before a commissioner authorized to do so by law. The conclusion that the claimant's pleadings not supported by credible evidence is deemed abandoned does not flow from any established fact or logical derivation from law. What the defendant's counsel did not consider before reaching his erroneous conclusion is Section 109 of the Evidence Act 2023, which provides as follows. Of Section 109 of the Evidence Amendment Act 2023, which provides as follows. Any affidavit sworn before any judge, officer, or other person duly authorized to take affidavits in Nigeria, whether in person or through audio-visual means, may be used in the court in all cases where affidavits are admissible. This means that the witness deposition can be made either in person or through audio-visual means. There is neither pleadings nor question put to the claimant as to how he deposed to his witness statement on oath. It is a jumping of law and logic to come to a conclusion that because the PW1 was not in Nigeria on the day the oath was sworn, his deposition is incompetent. The gap between that logic and Section 109 of the Evidence Act is as wide as the biblical great gulf in the biblical story of Abraham and Lazarus in Luke chapter 16, verses 19 to 31. I shall proceed to consider whether the evidence elicited under cross-examination of PW proved, as was vehemently contended by learned counsel for the defendants, that his statement of oath was not sworn to before the Commissioner for Oath as required by law and therefore incompetent and inadmissible in evidence. The law is well settled, firstly, that once a fact has been reduced into writing, oral evidence would not be admitted to vary and or contradict the facts contained therein. Secondly, and more importantly, evidence elicited under cross-examination is inadmissible if on facts pleaded is inadmissible if not on facts pleaded either by the adversary or by the party being cross-examined. Okay, evidence elicited under cross-examination is admissible if on facts pleaded either by the adversary or by the party being cross-examined and not otherwise. There is this popularly accepted error that in cross-examination, the sky is the limit. This is not true, and its popularity cannot make it true. Cross-examination is limited by relevance and pleadings. See Isheno versus Julius Berger, Nigeria Limited, 2018 citations applied, where the Apex Court Paniki Toby JSC said, the discipline of law is one which is characterized by limitations here and there, and cross-examination cannot occupy such a tall and enviable place in our law of procedure. Relevancy is a limitation in all the three types of examination, including cross-examination. In Adama and others versus Kogi State House of Assembly and other citations supplied, the Supreme Court held evidence obtained in where Jimino versus Bakeji Supra, Italic supplied, citing Dina versus New Nigeria Newspapers Limited Supra and Aknocha versus Aknocha Supra. Put differently, evidence elicited in cross-examination is inadmissible inasmuch as it is not supported by the pleading of either party. Punch Nigeria Limited versus Enyina, citation supplied, SPDC versus Anaro Supra, ITA and Ekweyon Supra. That is to say, evidence extracted under cross-examination, but which was not pleaded and upon which no issue has been joined and canvassed goes to no issue. Isheno and Julius Baja, citation supplied, Ojo and Kamalu Supra, Waluchem and Gudi Supra, Warami and ACB Limited Supra. The corollary, therefore, is that evidence obtained in cross-examination on matters that are pleaded, that is, on matters on which issues were joined, is admissible. Addison and Governor of Ekiti State citation supplied. See also Dagash and Bulama citation supplied. Olumoriti versus Idemeko citation supplied. I have scanned through the entire pleadings of the claimant as well as that of the defendants, and I cannot find where the fact that PW was never in Nigeria to depose to his written statement on oath. There's also nothing on the face of the written statement on oath of the PW showing that it was not sworn to in the registry of this court. The usual thing for a counsel who elicited any evidence in cross-examination which he thinks is relevant is to apply to the court to amend his claim or defense in order to bring pleadings in line with evidence on record. See Polaris Bank PLC versus Mr. W.A. Clifford, citation supplied. So, can the evidence elicited from the PW under cross-examination on facts nowhere pleaded by either of the parties In the absence of an amendment, bring the pleadings in line with evidence on records. In the absence of an amendment, to bring the pleadings in line with evidence on records, go to any issue as to render the written statement of the PW incompetent and therefore inadmissible? I think not. Furthermore, can the oral evidence of the PW elicited under cross-examination vary the contents of the written statement on oath as to where and before whom it was sworn? I still think not. Now, assuming for a moment, but without so deciding, that the evidence elicited under cross-examination of PW1 can in law amount to varying the contents of his deposition to show that the PW did not swear to his written statement on oath before the commissioner for oath. Then, assuming the written statement on oath of PW rather had on his face that it was sworn to before the claimant's counsel in his chambers and under cross-examination, the PW had testified that it was rather sworn to before the commissioner for oath at the register of the court. In law, can this evidence be admissible to prove that such written statement on oath was sworn to before commissioner for oath, contrary to what is written on his face? I think not. In the light of all the above, therefore, I hold that the evidence elicited from the PW under cross-examination cannot and does not vary or contradict the fact as stated in his deposition that it was sworn to before the commissioner for oath without establishing that none of the method of swearing to an oath as provided by section 119 of the Evidence Act as amended, personal or visual, was used. On the whole, the objection on this ground fails and is dismissed. Merits of the case. The major complaints of the claimant are raised, nor the report of the external assessors. I have considered that issue, and I came to the conclusion that the complaint of the claimant is genuine and he was not given fair hearing. The second complaint is he was dismissed on 31st October 2018 based on a report of disciplinary committee which was only signed on 7th November 2018. In my consideration, I found that to be true, and I came to the conclusion that the dismissal based on a report that was not yet before the committee was wrong, and accordingly, the claimant was not granted fair hearing. His case succeeds, and for the avoidance of doubts, the claimant's case succeeds in part. For the avoidance of doubt, it is hereby declared and ordered as follows. A declaration that an allegation of plagiarism against the claimant cannot be made against the claimant in the absence of the works or publication of a particular author or authors the claimant has purportedly plagiarized, specifying what part of the works were copied, printed, or passed off as the original works of the claimant without the claimant having acknowledged such works. B, a declaration Okay, it seems I'm the only one on the Zoom now.
We are here, sir. We are with you, sir.
You are with me and you did not answer when I said this is a judgment of the court.
I didn't hear that, sir. I didn't hear that aspect.
Okay. But you had the judgment to the end.
No, sir. I only had up to the first declaration relating to plagiarism.
Yes. The next one is I voided the dismissal, and then I awarded that for 40 million.
Thank you very much, sir. As the court pleases.
Okay.
Yes, sir.
You are who? Is this Olowoyeye?
Olowoyeye, sir. Olowoyeye, sir.
We are grateful to the court.
We are grateful to the court, sir, and this for bringing the injustice perpetrated 6 years ago to an end 2 days before the 6th anniversary of the injustice. We are sincerely grateful to my Lord.
Okay, this is the anniversary. Today is 29 November.
Yes, by 31st November, 31st October, sir.
Okay, yes.
29th October, by 31st October.
The anniversary.
Yes, sir.
Yes, has the claimant counsel, is he online?
The claimant counsel that is speaking.
Is the defendant counsel online? Not. I think it's all right. So you can't hear them. The judgment will be for collection tomorrow.
Thank you very much, my Lord. Grateful, sir. Yeah. My master, thank you.
AK NICN/AK/25/2023. Abiodun Olarenwaju and Fatobas College of Health Sciences. Anybody?
Yes, sir.
Any announce appearance, please. Amos. Filani. Spell.
Hilary is spelled I-L-A-R-I.
You are for
the claim.
Yes, who is appearing for the defendant?
May you please, my lord?
Yes.
My name is Dr. Omoteye.
Dr.
Omoteye.
Dr. Omotoye.
Yes, sir. My lord, I hold the brief of Dr. Alfred Rocco Filani for the defendant, sir.
Brief of Dr.
Alfred Rocco Filani for the defendant.
Yes.
My lord, we filed our written address on the 28th day of May 2024 and served same on the claimant, sir.
You filed it on
the 28th day of May 2024, sir.
Yes.
And we have served same on the defendant.
Did you file a reply?
No, we were not given opportunity of seeing the written address of the claimant. Because same has not been served on us. We don't know whether he has filed. Anyway. We don't know whether the claimant has filed his written address. So we do not have opportunity of filing reply on point of law, sir.
Larry?
My lord, we have filed.
We filed our final written address on
the 20th of June 2020.
24 June. Are you hearing him?
Very well, sir. I can hear him very well, sir. We do have a copy. That was not served on us, sir.
2024, which I confirm because I've seen it.
Yes, sir. We do not have. We were not served with this address. We were not served, sir.
So what do you want?
No, sir. We want to beg for another date and to want to urge my friend, Mr. Larry, to serve us a copy of his address so that we will not be shut out of the opportunity of filing a reply to same if need be, sir.
My lord.
Yes. Where is Dotun?
Presently, I am in Ekiti State, sir.
Okay.
Yes,
you
sir.
are from? Are you?
Yeah, I'm from.
Okay. Well, I don't know what to say. You have filed, you have arranged, he has not received it up to now.
No, sir. We see it's our right, sir, to file a reply on point of law if need be. If Adebini has given us the opportunity of seeing this.
We have heard you. Please allow consent.
Oh, as copy, sir.
My lord, I didn't know immediately when we filed, when there was a confirmation that it was not that, I came to the belief to confirm that the process has been mobilized for service. Then thereafter, my principal told me to scan the process so that I can forward to their principal. But I wouldn't know whether it was forwarded to when they said they won't find the.
So what do we do now? What do we do now?
Right. We have filed negative document, my lord. We will see the asking for a date, my lord. Maybe I will maybe we can then why they are.
So what date is the application for another date?
Yes, my lord, we are not opposing.
Thank you. When do we come back? How soon can you arrange for him to have it?
My lord, will get it ready to be. My lord, I didn't have it, but it's only the number that we have. So I can forward it to him on WhatsApp when I scan it.
How long will it take?
No, within today and tomorrow, so it can be done, my lord.
Give us a date.
So maybe I will collect this number from the
On our part, is convenient, sir.
That is convenient, my lord.
Bearing in mind, a judgment could be ready before that date, all right?
For the copy, sir.
So that when we adopt, we proceed to judgment.
As the copy, sir.
So case adjourned to Yes, November 2024 for adoption of final written addresses.
As the copy is.
Ramos Green.
We are getting sir.
Because of the network issue, I don't know. Should we come physical to avoid this network issue?
Well, look, we on my part, my network is stable here. I'm comfortable with the virtual hearing, sir.
All right. All right. What we do is once we have connected, our program might check whether you hear it or not. Isn't it?
As a copy, sir.
Thank you. Any other matter?